In this discussion, we'll just give a quick overview of the expression terms of the contract. Now, terms of the contract can be express or implied. If they're expressed, it just means if it's a verbal contract, that's what was said, and so it becomes a term. Or if it was written, it's expressed in writing. So terms can be either expressed or implied. I like to say implied terms are terms you can't see. You don't think they're in the contract, but in fact they are. So they're different to express terms. Express terms have been heard, as it was said, or it was expressed in writing. So an example of an implied term. You go along to Halfords and buy a bulb for your car. There is a term implied by the Consumer Protection Act that the goods must be of satisfactory quality. So as you go along and ask for your bulb, you don't say that, they don't say that, but because it is a contract that falls within the Consumer Protection Act, that implied term is there, that the goods have to be of satisfactory quality, and other terms are implied as well. But implied terms can also be implied from a course of conduct. If you've done business in a certain way for many years and then you continue on that trend, and then one day in one of the contracts you forget to include it, then you can actually have that implied from a previous course of dealing. You could have it implied from a trade custom. You could have it implied by the courts. One example of the courts implying a term is where the party was making a contract. If an onlooker was looking at the contract and was asked, do you think they would have agreed that term A should be a term? The person watching would say, well, of course. Well, this is known as the officious bystander test, and this is another implied term. Now, in terms of the contracts are then classified. They can be very important terms. The effect of breaching them is the party who suffered the breach can treat himself as discharged from the contract or elect to go on with the contract and claim damages. And then there's less important terms, and they come under the classification of warranties. And a breach of a warranty entitles the person who suffered the breach to claim damages. And then there's another type of term which is called, it's sort of in between a condition, a very important term, and a less important term, a warranty, and it's called an intermediate term, some say. Others say an nominate term. You can't nominate which it is. So what happens then, the courts will look at the effect of the breach of this type of term, this sort of intermediate term. If the effect of the breach is very serious, they'll treat it as a breach of condition. And if the breach isn't so serious, they'll treat it as a breach of warranty. And there you have a quick overview of terms of the contract.